the lecture on Indian patent. Okay, Indian patent. I have already put the study material. Have you downloaded it? Study material, Indian patent. Have you collected?
Yes, sir.
Okay, okay. Now, first one, what is IPR? What is patent? First, what is patent? Patent is the exclusive right, is the right, adhikar, right, granted by the government to the inventor. So this is the right granted by the government to the inventor for an invention which is a new and inventive solution, which is a new and inventive solution to an existing technological problem. So what is patent? I repeat it. What is patent? Patent is an exclusive right granted by the government to the inventor for an invention, not for all invention, for invention, which is new and inventive solution, which is a new solution and inventive solution to an existing technological problem. Okay? And this intellect, that the intellectuality, it is also now considered as a property. And you are able to register this property under government, like land registration, like your building registration, etc., which are also a property. Similarly, your intelligence is also a property. Okay, and this is known as IPR, that is the intellectual property right. So IPR, that is intellectual property right. Mind that, IPR, intellectual property right. Okay. Now, what are the requirements for invention to be patentable? All inventions are not patentable. Mind that. Some of the inventions are patentable. And for such patentable invention, it must fulfill some criteria. So what are the criteria that should be fulfilled to patentize an invention? First criteria is the novelty. Novelty, like novel corona. Novel means new, novelty. The invention must be new or novel. Mind that. The invention must be new or novel. Means that the invention must never have been made before. What is new or novel? New or novel, that means the invention never have been made before, or carried out before, or used before. And thereby this invention is not known in existing public knowledge. So this invention, this information, this knowledge is not within the existing public knowledge. Existing, that means the present public knowledge. And this is known as prior art. Mind that the most important term, prior art. P-R-I-O-R, prior art. Prior art, that means it is not known in existing public knowledge, called prior art. So, if any invention, if the matter of invention, if the output of the invention, if the techniques, new techniques, or the new product, or the product that has been developed by your research, it is a new one, it is a novel one, it is not within the existing knowledge of the public, then it is a novelty. And if your invention has any novelty, is any novelty from the viewpoint of process, from the viewpoint of method, from the viewpoint of the product, from the viewpoint of design, then it is patentable. So all the inventions are not patentable, mind that. The invention which have a novelty from the viewpoint of process, from the viewpoint of method, from the viewpoint of product, from the viewpoint of design, etc., etc., then these are patentable. That means these are novel inventions. So novelty is the most important criteria to patentize a invention product. Number two, what is the second criteria? That the industrial application. If we patentize our research outcome, it must have some industrial application. That means this knowledge output of this research must be utilized in the industrial sector, and we can able to use this knowledge for commercial production. It must be capable to being made or used in the industry. This design, this methodology, this product must be used in industry, in commercial purpose, for the benefit of the society, for the benefit of the country, for the benefit of the world, etc. So there is the industrial application. So second criteria, that means the invention must fulfill the industrial application. What is the third criteria? That is not publicly or commercially disclosed. Mind that. If you like to patent your research output, it should not be commercially disclosed before patentization. It should not be publicly disclosed through different periodicals, through different journals, etc. It should not be published before the patentization. That means this is not the property of the public before patentization. So not publicly disclosed or publicly
Or
disclosed or not
commercially
commercially disclosed. Patent application must be filed to any disclosure to the public. Patent application must be filed, must be submitted to the patent office before any publicly disclosed or commercially disclosed. Okay? And for example, if you develop a particular drug, this active ingredient should not be disclosed in your published journal, in your published paper, in your published book, in your published periodicals. If you already published your matter, if you already published your technology, if you already published your design in common journal, in general journals or periodicals, etc., then it would be the public property, it would be the commercial property. So it is commercially disclosed, it is publicly disclosed, it should not be patentized. So these are the three important criteria that should be fulfilled before patentization. One is known as the novelty, second one is known as the industrial application, and third one, it should not be publicly or
commercially disclosed. Or
publicly or commercially disclosed. Okay?
Disclosed.
And in our country, generally, when an invention product is patentized, as per Government of India rules, the protection period is given for 20 years. Protection period. That means this product is for 20 years for that inventor. And if any industry use this product memorandum of understanding should be formulated between the industry and the inventor. But beyond 20 years, after 20 years, mind that this becomes the public domain. This is open to the public domain and it becomes the public property. It is not the property of that inventor. So in India, generally the protection period is given for 20 years maximum, And after that, this property, that means this process, this design, this product, whatsoever, it becomes the public property. It becomes the commercial property. Okay? Now, next point that we like to focus, that is step-to-step procedure for patent registration in India. Step-to-step procedure. What are the steps that should be followed to register your intellectual property? There are 6 steps that should be followed as per rules of India government for patent registration. Okay. First step, that the patent search. Patent searching is the most vital point and crucial point. Most vital to save the time, to save the money of the inventor, to save the money, to save the time of the inventor. That the patent search. That means before filing your invention in patent registration office, you must search out worldwide searching, worldwide, not countrywide, worldwide searching is vital. That means whether it has already patentized by others or it is already submitted for patentization by other inventor or not. So if any inventor from any corner of the world already filed this type of invention or same type of invention, then you should not submit it for patentization. But if such patent searching give a negative result, that means such type of invention is not submitted, is not patentized by anyone throughout the world, then this invention has a justified claim for patentization. And you also filed it in Indian Patent Registration Office. So this is the patent searching. So it is most important, patent searching, and it should be followed before filing your invention product to save the money, because for patent registration, a money should be submitted to the government registration office. So if it is already patentized by other, and if you file it again, then your money will be totally wastage. So to save the money, to save the time, the patent searching is most important. Now, second step, if the first step gives the negative result, that means there is no information is coming that such type of invention has already submitted or already filed anyone from any corner of the world for patentization, or it is not patentized by anyone, then you come to the second step. What is the second step? There is the patent drafting. Patent drafting. Patent drafting, that means as per the schedule form of Patent Registration Office of India, you filled in this form and you also use techno-legal language. Mind that, not the scientific language. Techno-legal language, the most important term. Techno-legal language should be used. There is a technical term as well as the legal term that should be included in your drafting. And that techno-legal language also focus with or without claim. With or without claim. Without claim is the provisional specification. Without claim is the provisional specification. And with claim is the complete specification. Mind that there is a two type of specification in techno-legal language. One is known as without claim, that is not the provisional specification. That means these are the information such and such and such, but I have no claim. And another one with claim, there is the complete specification. And this specification focus the field of invention, in which field the invention has been carried out. Detailed description of the invention, that means what the methods you have adopted to find out this material, what are the steps you followed, what is the purity of your product, what is the stability of this product, what is the structure of this product, and such and such. So the detailed description of the invention, so that any person can perform this invention if desired for confirmation. So this is known as specification. So specification focus the field of invention and detailed description of the invention. Because if the patent office desired to confirm the technology, to confirm this method, to confirm this output of this invention, then through your description, anyone can able to repeat this method and to find out whether the outcome is achieved or not as per claimed by the inventor. So that is the specification. And legal part focus the claims of the invention, the demand of the invention, which define the legal protection sought by the inventor. Legal protection. The claim, that means a legal protection. That means after my submission, anyone, if submitted, then it would be rejected. On the basis of the priority, the inventor who filed this invention at first would be considered, would be accepted for registration. So that is known as the legal protection. And for this reason, techno-legal language should be used for specification. One is without claim and another is with claim. So without claim, specification should be submitted at first and then with claim. This is step 2. Next one, step 3, that is the patent application filing. So this is the drafting. After completion of the drafting and correction and its modification and its improvement, then patent application filing to the registration is the third step. So drafting, that means you also prepare the techno-legal language, you also formulate all this description covering the techno-legal language, and after its correction, modification, improvement, etc., etc., when the drafting is okay, then step 3, you also follow the step 3. That is you also follow the step 3, that is the patent application filing. Patent application filing. Provisional application is generally filed to claim priority date over other applications. So first you filing the provisional application without claim, provisional application. Suppose today is April 13 April 2020. Okay. If I feel that my invention has some novelty, this molecule is not invented till now at any country in the world, after proper searching, then I also filing it to the patent registration office without any claim at first, which is the provisional submission. Why? Because it would be recorded 13th April 2020, entry date. If anyone filing this material in May or June, am I clear? Then it would not be considered. It would not be registration. It would not get the registration. So, to get the priority, provisional patent application should be filed off. Okay? As per Indian Patent Act 1970. But the most important one is that after provisional patent application, after filing of the provisional patent application, within 12 months, the complete specification filing should be maintained, should be performed. Suppose in April 2020, we filed the provisional application. Then within March 2021, within March 21, that means within 12 months, the complete specification with claim should be submitted. Otherwise, it will be rejected. Am I clear? So first one, provisional submission, provisional filing. Why? Because provisional filing gives you the priority. If you like that, after complete invention in 2021, that means 2021, I will submit it. Now in June, July, or September, October, if any inventor from any country filing this invention, then that inventor will get the credit. You will not get the credit. So if you ensure that your product, your invention outcome has some novelty, then to get the priority, you must submit the provisional submission at first, provisional submission. And within 12 months, you also submit the complete submission with proper claim. Okay? There are 6 different types of filing. One is known as ordinary application, because ordinary application is require more time. PCT, what is PCT? PCT, Patent Cooperation Treaty. Patent Cooperation Treaty. It is an international patent law. Patent Cooperation Treaty, TREATY. PCT, that is the Patent Cooperation Treaty. PCT, National Phase Application. PCT, International Phase Application. Number 4, Convention Application. Number 5, Divisional Application. And number 5, Patent of Addition Application. That means after provisional submission, within 12 months, you also submit the complete specification. And at that time, if you like to add something more than the provisional submission, you have the ability, you have the power for such addition. Okay, so this is the third step, that is the patent application filing. Now step 4, publication of patent application. Publication of patent application. Now after filing of this patent to the Indian Patent Registration Office, after expiry of 1.5 years, that means after expiry of 18 months, after 1.5 years, that is 18 months from the date of filing or the date of priority, whichever is earlier, the application is published in an official journal of the Patent Registration Office. Patent Registration Office that have a journal. In that journal, they also upload it. Okay, that is uploaded so that it become open throughout the world. So that any inventor from any country, from any corner, can able to challenge this type of invention. They can able to claim that no, he or she has already invented this material long before in respect to the date claimed by that inventor. So whether this question is coming or not, after expiry of 1.5 years of the patent filing, the patent registration office also upload it in their official journal and is open to public to raise any objection, if any objection against this invention or not. So that is known as the publication of patent application. So it is remain in website. Am I clear? Remain in website. Now next, patent prosecution or examination. Patent examination. Now patent application is examined only when a request for examination has been filed. So after uploading the material in their journal, okay, the inventor put a request to the patent registration office for examination. And the request for examination has to be filed within 48 months of application filing date. Within 4 years, maximum within 4 years of patent filing date. Suppose in 2020, if we filing the patent, so within 2024, within 2024, the inventor must put the application to the patent registration office for examination. If the inventor put his or her application beyond that period, beyond 4 years or after 4 years, then it would be regretted. It would be regretted. So patent examination is most important step, and it should be requested by the examiner, by the inventor, to the patent registration office for examination, and that application should be submitted within 4 years, maximum within 4 years after the filing date or date of priority. The patent examiner, after examination of the report, after examination, prepare a report and submit to the patent registration office. And that patent registration office will transfer this question to the inventor. That these are the questions raised by different inventors, different scientists throughout the world against your claim about the novelty, about your applied value of the product, about the quality control of your product, and others. So this is the fifth step, that is the patent prosecution or patent examination. Okay? And mind that after receiving these questions from the patent registration office, the inventor must prepare the answer and submit it to the patent registration office within 12 months, maximum within 12 months, within 1 year. So when the patent registration office transfer this question to the inventor for proper justification, then within 1 year, then within 12 months maximum, the inventor must submit his or her answer against the question raised by the different adjudicators, different examiners, against the different claims raised by the inventor. So there is maximum 1 year time. If the inventor is unable to give his or her answer within 1 year, then the patent will be rejected at first. Now the step 6, the last step, that the grant of a patent. Now, after filing of the answers against the question raised by the inventor, raised by the examiners or adjudicators, okay, the patent registration office will analyze the question will analyze the credit of the answers sent by the inventor. Whether or not the inventor can able to justify his or her claim and nullify the questions raised by adjudicators or examiners. On the basis of the analysis of the patent registration office in presence of so many experts, if the expert committee feels that the answers are justified, answers given by the inventor are justified, and the different questions raised by adjudicators or examiners from different corner of the country or the world are illegal, are not scientific, are not proper, then they give the honor, the invention that has been done by the inventor and issue the registration certificate. And the invention is under Indian patent registration. But if the answer is negative, that means when the board of the examiners, through analysis, through critical analysis, came to the point that the answers given by the inventor is not proper. These are not justified properly. The queries raised by the inventor, raised by the examiners or adjudicators. Then the application is rejected and the invention is not under Indian patent registration, and so IPR is not granted. So intellectual property right is not granted, that the registration certificate is not granted, and this application is rejected. So if the examiner is not satisfied with the reply or the arguments of the applicant or of the inventor, okay, that there is no novelty, the product is not industrial applicability, and it has no new insight about the invention, then the patent is rejected, the application is rejected, and the registration is not given against such invention. So this is all about Indian patent steps that is followed for Indian patent, and this is about IPR or intellectual patent property right, intellectual property right. Okay. Have you any question? Have you any questions?
ক্রাইটেরিয়ার মধ্যে কি সবগুলাই ফুলফিল করতে হবে?
হ্যাঁ, ক্রাইটেরিয়ার মধ্যে সব ফুলফিল, দ্যাট ইজ ইট মাস্ট বি নোভেলটি, এটা নোভেল হতে হবে, নিউ হতে হবে। Next one, it must be industrial application. That means the method or the design or the product must have industrial application. That means it must be commercially produced. Otherwise, your invention has no value. And next one, that till filing, your invention is not the public property. Your invention is not the commercially disclosed. Your invention is not publicly disclosed through any journal, through any periodicals, through any published books, etc. If you already published your invention through journal, okay, and then you filed it for patentization, then it would be rejected. Because at the time of searching, so many information will come coming in internet that such and such invention, such methodology, such design, such product already published in such and such journals, and thereby it is a public property, it has no novelty. So these 3 points should be fulfilled, Am I clear? Novelty, industrial application, and publicly or commercially should not be disclosed.
এইগুলো কি স্যার যে টাইম গুলো দেওয়া আছে ওই টাইমের মধ্যে না হলে রিজেক্ট হয়ে যাবে সবগুলো?
That means suppose you apply provisional application, then within 1 year you must fulfill the complete application. Otherwise it would be rejected. Okay. Similarly, within 4 years you must submit for examination. After receiving the questions from the adjudicator, within 1 year